Hello there. My name is Robert Marks, and I'm a business law attorney with Mercury Legal Group PLLC. This is the Mercury Legal Sidebar, a legal podcast where I will discuss things of note, of interest in the legal world. Thanks. I appreciate you watching. Let's dig in. I'm sure you've heard over the last couple of weeks the Disney Plus wrongful death case. It was very popular in the news, but just in case you haven't, let's do a brief refresher. A gentleman in 2023, he was at a Disney restaurant, a Disney Springs restaurant, that he was served something that he was allergic to. He had an allergic reaction. He later died. His wife filed a wrongful death suit against Disney. Disney recently, and when I say recently, I mean a month or so ago, filed a motion to dismiss the case. Their reasoning was that he had a free trial to Disney Plus back in 2019. Disney Plus's terms of service require all users to arbitrate all disputes with Disney. Arbitration is an alternative dispute resolution. What's interesting, and I think what highlights the curiosity of this case, is Disney is a big conglomerate. They own a lot. You can easily become a customer of Disney, whether you're on your TV watching a show, or you're in Florida enjoying a ride, or you're at a restaurant, at a shopping center that Disney owns. If this sounds ridiculous, a lot of people think that it is. Disney was trying to force the terms of service that this man agreed to back in 2019, so 4 years before he died, that expressly required any dispute, not just disputes related to Disney Plus or anything like that, any dispute with Disney to be arbitrated instead of filing suit. Now, the wife's wrongful death claim was on behalf of her husband who died. So Disney was arguing that this applied and that they should be able to arbitrate. And from a legal look only, it is a valid interpretation. Disney does have the right to enforce this arbitration clause and force this wrongful death suit to be arbitrated. But, there was obviously the PR disaster in this. And this is where sometimes it's always a good idea not necessarily to listen solely to an attorney, or if you have an attorney who gives you legal advice and maybe a sprinkling of sage advice too, because sometimes it's not the best course of action to enforce everything that you can enforce. And, there is precedent to this. There was actually a case that was dismissed against DirecTV where it was discovered that the plaintiff had signed a mobile agreement with AT&T that included an arbitration clause. And that arbitration clause and that mobile agreement was done before AT&T had even bought DirecTV. And so that was enforced. To be clear, Disney, probably mainly through public pressure, did withdraw their motion to dismiss the case, and it is proceeding through the courts as it probably should. But let's get into this. That's the story. Everyone heard that and read that in the news over the last couple of weeks. But you're probably asking yourself, okay, what is the terms of service? What is arbitration? Why is this important to me? Well, let's dig in. A terms of service, or terms of use, or terms and conditions, is nothing more than just a legal document that outlines the rules and regulations that users must agree to before they use a service, a website, or an application. And, there's standard key components to it. Like, you have to accept the terms, how they modify the agreement, what are the user responsibilities, what are the provider's responsibilities, what sort of account information are they retaining, what sort of, if any, ownership rights and uses are allowed, privacy policy, how they can terminate the service, both the user and the provider, what governing law applies to any disputes and liability information. But here's the most important part and the relevant part. It usually specifies dispute resolution. And for the most part, terms of service will try to use an alternative dispute resolution, whether it's arbitration or mediation or whatnot. Because ideally, these big corporations, it's extremely cost prohibitive to combat for a variety of lawsuits across the country or across the world, whereas arbitration can be, it's fixed costs and it's very quick and expedient, which they want. So now most people will not even scroll through. They'll just agree to these terms of service. They don't understand what they're doing. And for the vast majority of time, it's not that big of a deal. But you need to understand that sometimes, especially when you're dealing with a big corporation like Disney, is that this could affect you later in life. This man probably had no idea that in 2019, when he was signing up for a free trial on his PlayStation to watch Disney Plus for a month. So he didn't give Disney any money, but he did sign up. He created an account, signed up at his free trial, watched some good quality content, maybe it was Star Wars, and not realizing that that was potentially putting his wife's ability to recover from a wrongful death claim 4 years in the future. I mean, it's insane. That is legitimately insane. But from a legal perspective, it's enforceable. So it's something to consider, something to just be aware. I mean, I am certainly not advocating, not enjoying streaming or other services or applications, but maybe just be a little aware of what you're agreeing to and understanding what you're giving up to do it. I mean, that's, I think at the end of the day, a more informed individual is a better individual, better society. Let's be aware, you know? And I think that creates a really interesting conversation where, you know, maybe these terms of service, these, you know, these agreements should be presented differently. You know, there's this concept in contract law about unconscionability, you know, an adhesion contract, a contract that is, you know, so one-sided that it's unconscionable and shouldn't be enforceable. You know, and there's certain rules and regulations involved in those situations where, you know, certain terms have to be a certain size and apparent, and there has to be a expressed acknowledgement and everything. And I think a good discussion to have, obviously any terms of service worth its weight is going to be multiple upon multiple upon multiple upon multiple pages, you know. But maybe it would be smart to have some sort of requirement that there should be some expressed acknowledgement, and not just expressed acknowledgement that you read it. That's ridiculous. Expressed acknowledgement saying, you know, by, you know, signing this terms of service and utilizing this website or application or whatever, you understand, and that's check marks. You're agreeing to an alternative dispute resolution. You understand what arbitration is. You know, have it be a little more work, because this is unfair, but life is unfair sometimes. So hopefully you kind of understand terms of service a little better, maybe solutions that we can do. But what about arbitration? You know, everyone knows about court filing suit, suing someone, going before a judge, maybe a jury, opposing sides. Here, have your day in court, hear your thing, and then getting some form of compensation for your damage. But what's arbitration? Well, arbitration is, like I said earlier, an alternative dispute resolution where both parties agree to submit their conflict to a neutral arbiter, kind of like a judge, and he will hear the evidence, hear the arguments from both sides, and then make a decision. And that decision is usually binding. Now, that is different from mediation. Let's be clear. Generally speaking, anytime I advise a contract with a client, obviously there will be an alternative dispute resolution. For the most part, all parties don't want to go to court, you know, and generally speaking, it's always good to require some form of good faith negotiation, which is just both parties trying to work it out on their own. And, you know, if there's a dispute, sometimes that's hard. Sometimes it can be done, but sometimes it does need a third party, whether that's the court, an arbiter, or a mediator. Now, the difference between mediation and arbitration is mediation is usually not binding. You know, it's you go before a mediator, hear the arguments, he renders a decision that if both parties then agree to the decision, not on the front end, but on the back end, then it can be enforceable. And that's usually a great way to go about it. Whereas with arbitration, just to be clear, you're agreeing on the front end that whatever the arbitrator decides can be binding. So the main benefits of arbitration is speed, efficiency, costs, confidentiality, and the binding decision. So you may ask yourself, okay, why would Disney want arbitration? Well, it's pretty obvious. It's fast. It's a lot easier than going through the court system, wherever this lady filed. I think it was in Florida. It's confidential, whereas court records are, generally speaking, public information. And so it looks bad. I mean, at the end of the day, Disney doesn't want people to know that they or a third party who is managing and operating the restaurant. To be clear, I'm not insinuating Disney did it themselves. Served a gentleman something that he informed them that he was allergic to, and as a result of that, he died. Bad press, bad publicity. And ultimately, at the end of the day, that's what Disney was most concerned about. And so with this, it would be a confidential thing. So the wife would potentially get some form of compensation. It would be confidential and it would be quick versus, this case has been going on for over a year now. And that's slow, and that's a lot of attorney's fees and a lot of, potential for bad press, and just, it's a headache, and it's managing something that long is counterintuitive. So the main problem with that is, generally speaking, a plaintiff going through arbitration versus the court system in a situation like this would probably get lesser damage, lesser compensation. It's not as favorable. Now, to be clear, that person also gets the benefits of the speed and efficiency and everything, because mounting a case against a big conglomerate like Disney is also expensive. Now, yes, there are contingency fees, and hopefully her attorney is working on a contingency fee, meaning he gets a portion of any claim, any damage award that she would receive. And if they don't win, he doesn't get anything. So it's a gamble for the attorney as well. Hopefully that's how it's structured. I'm sure it is. But arbitration is very common. It's used in a lot of commercial disputes, consumer disputes, international conflicts, and it's favored, generally speaking, favored because of its quickness and the confidential nature of it. But it rears its ugly head sometimes where maybe it's not a good thing, because maybe statutory damages are different, if she was able to go to court, but now she can't go to court because of this arbitration clause. And, there's nothing wrong with parties agreeing to arbitrate. There's nothing wrong with that. But this case highlights an issue where a gentleman decided to watch something on a streaming site. And because of that, it created this potential loss of recovery for his significant other after he died. And that's just so far removed from the intent that it didn't make sense. You saw the news. It was covered in almost every publication. It was a mockery, a meme, a punchline to a joke that no one should have to tell. And it highlights sometimes the negativity of law. As I said earlier, I think that there's ways to go about this where the big corporation, heck, it's not even about being a big corporation. Small businesses have to worry about the same concerns that Disney has to worry about, but that where they can protect the interest of the business, but also maybe not completely isolate the benefits of the end user. And there it is. Hopefully you have a greater understanding of the complexity of this case. And more than just the case, a greater understanding of terms of service, arbitration going forward. At the end of the day, this Mercury Legal Sidebar, the intent of it is to give you something interesting, some little interesting factoid, some little interesting story, something from the legal world, but then apply it with an educational purpose. I think it's an interesting story, but part of that reason is it allows me to educate you on terms of service and arbitration. And that's my goal, is I want to entertain, but I want to educate. 2 E's. I'm sure there's a joke there. I don't know. But I really appreciate you watching. My goal is to do this twice a month, and I look forward to the next story. Thank you.